Before I turn the presentation over to Mickey Morris, I wanted to extend Taz's sincerest thanks to her and her colleagues at Rogers Morris Grover for putting this urgent information together for our members. I know we have a lot of information to cover, so go ahead and get started when you're ready, Mickey.
Thank you. Okay, I hope those of you on this call are safe and have fared well, and if you haven't, really, truly, our hearts go out to you. I myself am sitting here in flip-flops with no makeup and a T-shirt that I grabbed from my mother's closet. So we were evacuated and we are living out of trash bags. But I really wanted to have this webinar because so many of my Gulf Coast clients have already been reaching out to us with various questions related to the emergency exception, and I've already been receiving restoration contracts to review for clients. And so I thought it would be beneficial to get everybody who would like this information together at one time so that we can make sure everybody has the same understanding and try to address any concerns or questions you might have. And so we're looking at the chat. If you have questions, feel free to throw them at us, and we'll try to get to all of them as they come up. We know that we have some higher ed community college folks with us today, and so we will make a point of specifying as it relates to a particular statute or requirement if there's anything different as it relates to higher ed institutions or community college institutions. And we also have some charter school participants today, and so we will likewise do the same for charter schools. I'd like to introduce two of my colleagues, two other partners here at the firm, Sarah Langlois and Jonathan Brush. Jonathan is a litigator here at the firm who's handled a lot of construction litigation, but more specifically litigation post-disaster litigation as it relates to disputes with vendors over contracts that either were not signed, were not in writing, didn't contain critical material provisions, or didn't contain provisions or oversight or documentation sufficient to substantiate FEMA claims. And so we've had some clients who were jeopardized as a result of that. And Jonathan is going to share towards the end of the presentation some insight into making sure that those of you who are going to be seeking FEMA reimbursement for your losses do everything you need to do on the front end to make sure that you can process those claims and have all of the backup that FEMA is going to be asking you for. Sarah Langlois is well known to many of you, a frequent speaker on school law related topics, and she is going to be addressing issues as it relates to Open Meetings Act requirements and how to call, post, and conduct emergency meetings, including telephonic meetings. I know a lot of you are in a position now where your boards are trying to meet by telephone, may not be able to gather physically, and even if they can get together by telephone, you may not be able to get to the admin building to make certain postings and the like, so we're going to cover that as well. Hopefully you all are able to see the PowerPoint, and we will be going through it slide by slide. And for those of you who either don't have it or aren't in a place where you can see it, I know Tazbo has it and it'll be available. If you have colleagues or contemporaries at other institutions who would like a copy of it, you have our permission to share it with anybody you think would benefit from the information. Why should you take board action to suspend procurement laws? And this statute exists for exactly this type of situation. and it's found in 44.031H of the Texas Education Code. It applies to all goods and services related to a catastrophe or unforeseen weather event. And what's important to remember is it's not limited to just building repair. It can help you out if you need to purchase vehicles or have other types of equipment repaired or replaced or rehabilitated, in addition to cleanup efforts, dehumidification, and reconstruction. So it's important to note the scope of this exception. If your board is going to suspend procurement laws, it'll help you in a number of ways, including with supplies and equipment and other materials. But we're recommending that if you have not already done this, that you consider doing it as quickly as possible, because just in the discussions I've had in the past few days, it's become apparent to me that vendors and suppliers in the local area are going to be saturated with work. And if you have a list of pre-approved vendors or cooperatives that you typically deal with, I think those vendors are going to be maxed out in terms of their capacity, and I anticipate and have already heard that vendors and suppliers from all across the nation are going to be coming into Texas to try to help people get back on their feet, including public institutions like school districts. And so we want to make sure that you all have access to those vendors without having to go through a procurement, or without a co-op having to conduct a procurement to add those vendors to cooperative pools. You are allowed to suspend procurement rules if the delays imposed by statutory competitive procurement processes will substantially impair the conduct of classes or other essential school activities, and I think it's fair to say that that's where we are. No question. I've heard from many of you that, our board doesn't need to act to suspend procurement rules because we already have a policy that gives our superintendent authority to execute contracts in the case of emergency. That is true. There is a separate statute for that, and many of you may have emergency purchase provisions in your CH local or CV local policy, but those do not apply to procurement rules. So I really want to walk through with you all to understand the difference and why it's important to take board action and not just rely on a CH local or CV local policy delegation. So the statute that allows those local policies to exist is 440312C. Okay, the statute that allows the board to suspend procurement is 44031H. And here's the difference. 440312C permits boards to delegate the authority, so it's not an automatic delegation. Your district will have had to have adopted in their local policy a delegation to the superintendent or another designated person to, and this is critical, enter into contracts for the replacement, construction, or repair of school equipment in the event of a catastrophe, emergency, or natural disaster, if the repair is necessary for the health and safety of students and staff. So critically important is that this authorizes your superintendent to enter into contracts, and it's an authority provision that allows you all to enter into contracts without having to bring them to the board for approval of the vendor, the contract, and the expenditure. This statute does not speak to any exception to procurement rules. So this is a statute that, if it's in your CH local or CV local, will benefit you if you are able to use a vendor that you have already procured or pre-approved, or somebody that you're able to obtain from a cooperative board. But if you need to go out and find a vendor that you have not already procured or that's not on a co-op board, then this CH local or CV local provision is not going to help you get around the procurement requirements. So for charter schools are only subject to competitive procurement laws for construction or public works. So if you are a charter school and you only need a contract or a vendor to provide cleanup, dehumidification, debris removal, and the like, those are not going to be subject to competitive procurement for charter schools because those are not considered to be construction services. Those are only cleanup and remediation services. They will not become construction services subject to procurement until you get to the point where you are reconstructing portions of the building, reinstalling new flooring or remodeling. But the debris removal, the water removal, drying out, cleanup, and other mitigation efforts for charter schools, you are not going to need to adopt this resolution because you're not required to procure those services to begin with. If, as a charter school, your board has decided to adopt procurement requirements for non-construction services, and I know, Sarah and I know of a couple who have, in their charter opted, or by policy opted to comply with procurement rules for everything and not just construction, then your board's going to need to suspend those policy requirements for you either before the fact or after the fact by ratification. So for school districts and community colleges, the suspension of procurement has to be done by the board before the purchase and after the disaster. So moving to the next slide, how do you suspend these requirements? Well, now we're back to 44031H. This statute requires the Board of Trustees to determine, and it is implied, it's pretty more strongly implied or obvious from the plain language of the statute that this is something that the board does after a catastrophe or an emergency, because it states that that as a result of an unforeseen catastrophe or emergency, the board determines that the delay posed by statutory procurement methods would prevent or substantially impair the conduct of classes or other essential school activities. There is a statute in the Ed Code in 44.0312B that says an action that is required to be taken by the Board of Trustees. If the statute uses the phrase Board of Trustees rather than the district, that it's not delegable. So that's how we know that this statute that requires the Board of Trustees to make the determination that you don't have to comply with procurement laws is not covered in that CH local emergency purchase provision you have, because it's not a delegable determination as stated by 440312B. It's also important to note that under 44031H, it specifically provides a means by which procurement methods can be set aside in the event of an emergency, whereas the statute that gives the superintendent merely contracting authority, where he brings the contract back to the board for ratification at the next meeting, doesn't authorize the superintendent to avoid competitive procurement. So again, that's just a long way of getting back to where I started, which is just because you have an emergency purchase provision in your CH local authorizing your superintendent to enter into contracts does not mean your superintendent has the legal authority to suspend the procurement laws in doing so. And this is aligned with the guidance that TASB has given as it relates to the suspension of procurement as well. So we looked through TASB's materials very carefully to make sure that they also take the position that the Board of Trustees is the one that makes the determination that procurement rules can be suspended. We recommend that you do this by adopting a board resolution. How are you going to do that right now? That's what Sarah's going to address next on open meetings issues. But we recommend that you have your board immediately adopt a resolution that identifies the emergency. Obviously, it's Hurricane Tropical Storm Harvey, and declaring that the delay imposed by the procurement method specified in Texas Education Code Section 44.031H would prevent or substantially impair the conduct of classes or other essential school activities. We also recommend that the resolution clarify that it's for any contracts necessary for the remediation or restoration of buildings or property, so that it's clear it will cover not only repairs to facilities, but essential school equipment and personal property such as vehicle, technology, supplies, anything that you're going to need to get the school back up and running for the kiddos. The resolution should, since you're already going to do it, and your board is willing to, authorize the superintendent, once the board sets aside the procurement requirements, authorize the superintendent to negotiate and execute the contracts necessary to implement the disaster recovery. Well, why do we need to do this if we already have that other board policy that gives the superintendent authority to enter into the contracts? Well, here's why. If you go ahead and include in the resolution that the superintendent has the board's authorization to negotiate and execute the contracts, then it will not be necessary to bring those contracts back to the next regular board meeting for ratification. You can if you want to, but you're not required. If the board includes in there a delegation to negotiate and execute the contracts, then really what you should be limited to doing, just for purposes of transparency, is having the superintendent report at the next meeting following any such contract that he did enter into such a contract with the vendor, and here are the amounts, but the board will not need to act to ratify those if they had already up front given that superintendent the delegation of authority to negotiate and execute. So I'm going to turn this over to Sarah to talk about the mechanics of getting your board together to do this for you.
Thanks, Mickey. Hi, everybody. I want to reiterate what Mickey said. We sincerely hope that you all have weathered the storm as best as can be expected. And if you have not, then our hearts and prayers are certainly with all of you. And please let us know if there's anything we can do to help. We have been on the phone and email and text, et cetera, drafting lots of these resolutions that Mickey's talking about and helping to walk our clients through the nuts and bolts of how to deal with this aftermath and how to get everybody back to school and to give not only kids but adults as well a sense of normalcy while we all recover from this terrible storm. One of the things I wanted to point out with regard to the resolution is I've gotten questions about shouldn't we include a not to exceed amount when we're delegating authority to the superintendent for contracting. If your board will approve a resolution that doesn't have one, that's best, because at this point we don't know, and it's very hard to determine, to even start to get an estimate about how much these activities will cost. If you have a somewhat difficult board, who doesn't want to give, we all hear the, we're writing a blank check kind of things, to the superintendent, then, yes, you could put a not to exceed amount in there, but then somebody's going to have to be really careful to monitor that you don't exceed that, and if you get close, you go back to the board for more authority.
Yeah.
So I just wanted to point that out as well.
And for those of you who have typed whether we have a copy, a sample resolution, the answer is yes. We do have a template that we've prepared, and we will share it with TASBO so they can provide a link to it.
So moving on to, you found yourself in this situation, you need a resolution, you need to go to the board. Do you have to comply with the Open Meetings Act requirements, including the requirement that we post notice of a meeting no less than 72 hours before the meeting? The answer is no. This is a true emergency under the Open Meetings Act, and so we don't have to comply with the 72-hour rule. An emergency exists under the Open Meetings Act if immediate action is required because of either an imminent threat to public health and safety or a reasonably unforeseeable situation. There's also a separate provision in the Open Meetings Act that provides that the sudden relocation of a large number of residents from the area of a declared disaster within the school district's jurisdiction is considered to be a reasonably unforeseeable situation for a, quote, reasonable period of time immediately following the relocation. That's now. We certainly fall in this category. When I do Open Meetings Act trainings, I always say, this has to be a true emergency. This isn't, oh my gosh, I forgot to put something on the agenda. Unfortunately, we find ourselves, we are in a true emergency. And so we clearly fall within the parameters of the exception to the Open Meetings Act for emergencies. This requirement is applicable for charter schools as well, and so just be aware of that.
Okay, so I see a question here, a couple questions. One is on the not to exceed. We're not suggesting that the resolution has to have a not to exceed amount. In fact, it is our recommendation that you try to get your board to adopt it with no not to exceed amounts or dollar limits in the resolution. We're going to talk about the contract separately. You may have a board that insists on it, but I really would push back and explain to those boards that, look, if you tie us down with a dollar limit and it ends up being more money than we anticipated, then we're going to be delayed getting the work done. We're going to have to stop and come back to you to get more expenditure authority or go through maybe a more arduous process of amending the contract and getting approval. So I really would encourage you to try to explain to the board why you don't want a not to exceed limit in the resolution, and try to give them some comfort by telling them that you're going to put some controls in the contracts, and we're going to talk about that in a minute. Jeff Drury has a question. AE services, so professional services. Suspending the procurement requirements is only suspending the requirements under 44031. So if you have a professional service, you don't have to procure those anyway, so you don't need a resolution just for the professional services. But restoration, debris removal, cleanup, those are not going to be professional services. But if you do need an architect or engineer, the rules prohibiting you from competing them on the basis of price, those are still in play. You cannot suspend those. So if you need to go out and select professional services providers, you don't have to worry about procurement, but you do need to make sure that you start by making the selection on the basis of qualifications and competence, and then negotiate on price. That rule is going to stand even in an emergency. There's no emergency exception to that rule.
There are specific posting requirements if you're going to have an emergency meeting. The first requirement is the notice has to specifically identify the emergency that's justifying the short notice. And so what that would look like, and we have in a couple of slides a sample public notice, but that just simply says an emergency or urgent public necessity exists that requires immediate action of the board as follows: the damage caused by hurricane/tropical storm Harvey to district facilities and equipment. It's as easy as that, but it is a requirement that you have that in there. In terms of posting, the posting of the notice has to be posted in a place readily accessible to the general public and on your website no less than 2 hours before the emergency meeting. Or, now we've had situations with this as well, if your district already had a meeting posted for this week, but you need to add agenda items to to that already posted agenda to deal with the emergency, you can certainly do that. And you would just call it an emergency addendum to the agenda. You would still need to identify the emergency, and then that has to be posted for 2 hours as well. We've gotten some questions about, do we really have to post on the district website? Yes, if your website is up and functioning. No, if your website is down for technology reasons and is not working, well, then you can't meet that requirement. And that's, a good faith rule. Robert, I'm seeing your question. I also heard that the board can meet outside ISD boundaries if their facilities are unavailable to hold at their usual location. So that's a separate provision, not in the Open Meetings Act, that's specific to school districts, that requires school districts to hold meetings within their jurisdictional boundaries. And so I don't think that there's an exception for that requirement, because that's outside the Open Meetings Act. That's an education code provision. And it's just a finite rule that you have to hold meetings within the jurisdictional boundaries. Now, that being said, if you can't physically get to where your meetings are normally held, you can have a meeting via telephone conference, and we're going to cover that provision in a minute. The meeting notice has to be posted where you regularly post the meeting notices. For most people, that is going to be on a bulletin board that's in your central administration building. If your central administration building is underwater or you cannot physically access that building, then post in the next best location. So if that's at an elementary school, if or one of your other district facilities, if it's at a courthouse, also at the board president's house. For example, we're pulling at straws here, but if you can't get to, if your district facilities are underwater, and unfortunately for some of you guys, that's the situation, then post where, quote, convenient to post, and you will have met that requirement but inside the boundaries of the school district, with that caveat. There's also a requirement that you have to give notice to the news media who have previously requested to receive notice of special meetings no less than 1 hour before the meeting. And so your board secretary, the superintendent secretary will know who those people are because they normally send meeting notices to them. And so just be aware of that requirement as well. The next slide has a sample public notice for an emergency meeting where you can simply copy and paste and fill in the blanks. The first action item is to deliberate emergency remediation or repairs to district facilities and or equipment. That's to basically give the board an update as to where the district is. The second item there is consider adoption of resolution declaring emergency under 44031H due to catastrophic weather and delegating authority to the superintendent to procure goods and services necessary to repair and remediate storm damage. This is the resolution that Nikki just spoke about. And like Nikki said, we'll provide a template to TASBO of that resolution. The third one you might want to do now, or you can certainly wait. This is one that we've been getting questions about as well. This is, can we still pay our employees while they're out? Yes, you can, is the short answer. Even if you're not legally obligated to pay them, you would want to look at your policy DEA local if you subscribe to TASB policy services. Some districts have very finite policies about emergency pay provisions, and some have delegated authority to the superintendent to do that. Others have not. Particularly if you have not made that delegation, you'd want to bring a resolution to the board. But the same gift of public funds rules apply to where the resolution needs to state what the public purpose is in making that expenditure. Things that we have put in the resolution for our clients include such things like, for retention of employees. And there are other things. I don't think it's not going to be a gift of public funds so long as the board makes the determination that this expenditure meets a public purpose. And then 4, and again, this one can wait and be done later, but if you have a budget amendment ready to cover the expenditures relating to restoration and repair, then you can go ahead and put that on this on your emergency meeting agenda as well. Importantly, the items that are on this emergency agenda have to relate to the emergency. They have to be limited to items that are requiring immediate action. So in other words, we can't say we're going to post a meeting with 2 hours notice, but let's just go ahead and put all those contracts we were going to do at our regular board meeting, we'll just put them on here and then we won't have to have our regular board meeting. No, you cannot do that. It's got to be limited to the emergency. The next slide. Meetings by telephone. You have attended my Open Meetings Act training in the past. You've heard me say over and over, no, you cannot meet by telephone, only in an emergency. Well, again, we are unfortunately in this situation. This is an emergency. So we can have a meeting via telephone conference if the convening of a quorum at one location is difficult or impossible. So if your board members have evacuated, they are not in the district, and this goes to Robert's question as well, then you can have a meeting by telephone conference. Except for a lawfully authorized closed session, the telephone conference has to be audible to the public at the location noticed for the meeting and must allow for two-way communications. So if your notice of the meeting says we're meeting at the board president's house, then the board president has to, if people show up because they want to hear the conference call, he's got to either let them in or pull up a seat on the front porch. And it has to be audible to basically everybody who is there. That can be as simple as putting on the speaker on your iPhone. As long as it's audible, it meets that requirement. Very important, if you're going to be taking advantage of the exceptions to Open Meetings Act that allows meetings by telephone, it has to be audio recorded, and that audio recording has to be made available to the public. There's also a provision under the telephone exception to the Open Meetings Act that says, and you would probably do this anyway, but you're legally obligated to identify yourself before speaking. So whenever the meeting is called to order, if you have board members who are participating via telephone, then you would have them, can everybody on the line please state your name and identify your position. And so you would go around the room and have people do that. If you're a member of an institution of higher education, there's a different law that applies. It's 551.121 of the government code, and there are specific rules that are applicable to institutions of higher education. And there are different requirements as well for telephone meetings. So for example, one of those requirements is that in addition to being audio recorded and being audible to the public at the location that's specified in the notice of the meeting, it also has to be broadcast over the internet in the manner that's prescribed in the government code. So I would encourage you, if you are an institution of higher education and you subscribe to TASB policy services, look at your policy BD, that's B as in boy, D as in dog, legal, and it outlines the nuances that are applicable to institutions of higher education. So what if a quorum of board members is unavailable? And this goes a little bit to Robert's question as well. A quorum is not required for a board to act. So even if you can't get your board together, even over telephone, you can still act. You can still have, 3 members of the board, for example, approve your resolution if, and both of these unfortunately are applicable to us now, the district's jurisdiction is wholly or partly located in the area of a disaster declared by the President of the United States or the governor. We can check that box. And a majority of the members of the board are unable to be present at a board meeting as a result of the disaster. And so even if your board members can't call in, they don't have access to a landline, their cell phone is dead, whatever the situation may be, you can still act even without a quorum if these two caveats apply.
Oh, confusion between disaster mitigation and repair and renovation. We're going to talk about that. We have a couple slides talking about the distinction between remediation and public works. So we will get to that. Oh, I think we're there. Okay. Okay, let's talk about the contractual protections first, and then we're going to talk a little bit about the public works requirement and the distinction between construction services and non-construction services. We have handled a number of lawsuits in the wake of named storms and disasters where vendors rushed in and presented contracts that did not have a lot of controls or protections for the governmental entity, and it ended up being a problem because either the cost just ran away or the entity ran into problems getting FEMA reimbursements because of the, I guess, blank check nature of the contracts and the lack of oversight and documentation. So we strongly recommend, I know you all are in dire straits here, and I had one contract come to me from a client this morning, and they literally needed me to look at it in minutes because they had the people there on site ready to roll in within the hour. And it was a fairly good contract, but it was missing one provision that I know FEMA is going to want to see. So I want you all to be prepared and perhaps put an addendum together that, you know, these certain provisions will take priority over anything to the contrary in the contract, because you may not have time to go through a long drawn out negotiation and revision process with these contracts. One is to make sure that you have either in the contract or in an exhibit or attachment to the contract set unit prices or rates for labor and materials.
So not, you all can't see, but I'm holding up to Mickey a proposal that I received, a couple of hours ago from a client, and it just says, water extraction, drying equipment, monitoring and demo, $45,000, and that's it.
Yeah. So it's critical to know what are they charging you per hour of labor and the different classifications of labor. There are just cleanup laborers, there are project managers, there are people who are operating specialized equipment. They may have mold remediators or other people that need to be certified that are paid a different amount. So you want to see what those hourly rates are for those folks. And sometimes I've seen it as a daily burn rate where, they tell you what it's going to cost per day, but they still tell you how they arrive at that cost, and that's fine, but you're going to want to have that breakdown of unit price. You also, to the best of their ability, either to have unit prices for materials or what would be more common is a markup on materials at the actual cost rate. And that's fine too. Equipment use or rental. This is critical because if you don't have an hourly or daily rate schedule or for equipment rental, or if it's just the rental rate from the place that they rent it from plus a markup, that needs to be identified in the exhibit or the contract, because we've seen situations where districts were presented invoices for generators or dehumidifiers or other equipment who just sat on site for days and days and days, when really they were moving it around to different locations. It wasn't at the school site for all the days they represented it was, or there was no way to verify what the actual rental cost was to third parties. So you want to have some transparency on that. If feasible, sorry, Jonathan, you have something to add on that?
I do, and this comes from experience in the past. Everything Mickey said about the rate sheets is critically important, but look at the proposed contracts carefully to see if they permit subcontracting. Some of these contracts you'll see will allow the general contractor to subcontract out, and you need to make sure that the rate schedules they provide apply to subcontracted work, be careful of subcontract provisions that allow them to assign a markup on whatever the subcontractor charges, and try and strike those provisions.
Thank you. Next bullet, if feasible, you want to ask these vendors at a point where it is feasible to give you a not to exceed or a guaranteed maximum price once the damage is assessed and scope is determined. Now, obviously, when they're going in to dehumidify and remove trash, you are not going to waste time having them walk around the building and count the trash and the measure the water to give you a not to exceed amount. So the cleanup, just get it done. Get it done. They will give you a time and material schedule, hopefully. You need to require them to. Get it done. What I'm talking about is when you get to the point of, okay, we're going to put in new flooring, we're going to put in new ceiling tiles, we're going to remediate damaged equipment or damaged electrical facilities or appurtenances, or we're going to replace sheetrock. At that point, they should be able to give you a scope and some type of lump sum proposal or not to exceed amount for that work, with the understanding that the initial drying out and cleanup probably will not be practically able to be quantified. It's just going to be done when it's done. On the payment provisions, in the contract I saw this morning, it did say that the vendor was required to give an itemized invoice on a weekly basis, which is great because you want to be able to monitor on a week-to-week basis how the meter is running, so to speak, and not get a $2 million cleanup bill at the end of 30 days, having no idea what that was going to look like, especially if they haven't given you a not-to-exceed amount. So having them bill you on a weekly basis is a great idea so you can see how much money you're burning through and what their progress is. But it's also important to require that when they submit itemized invoices, that they need to have backup for that, whether it's a list of the workers or timesheets. And if they can't give you all of that right then and there, you want to make sure that they have an obligation to retain and maintain that information and documentation so it can be subject to audit, and you definitely will need it when FEMA comes to question some of these charges and ask for backup. The worst thing that could happen is FEMA asks you for it, you turn and ask the vendor for it, and the vendor says, well, we don't have that. We were just charging you a daily rate. We can't verify where we rented that equipment from or how much we spent or where we got the fuel. That's going to be a problem for FEMA. We know that from past experience. I'll let Jonathan speak about that. I want you also to be aware, because I've seen a couple of questions from districts about these kind of turnkey companies that will come in and do disaster remediation and help with FEMA claims, or just these loss recovery groups that will come in and say, we'll handle all of your FEMA claims and insurance claims, but we want a cut of the proceeds.
And I just had this, and they wanted 10%.
10%. Do not do that. You can get a consultant to help you with claims preparation or other type of public adjuster services for consulting rates, or they can give you a lump sum fee if you need it. But I would not allow a company to take a portion of your public proceeds for assisting you with that claim preparation. That is not the way it should be priced. Okay, we're going to talk, before Jonathan talks a little bit about FEMA, public works cleanup and bonding. So if your board adopts a resolution suspending procurement rules for your Chapter 44 or your 2269 contracts, you need to keep in mind that if the contract includes public works or construction services, you're still going to have to comply with payment bond and performance bond requirements and prevailing wage law compliance for the construction services portion of those contracts. So here's the difference. Construction, public works is just a fancy way of saying construction by a governmental entity. So the terms are interchangeable. But it becomes construction when you're actually rebuilding on a large scale or doing replacements on a large scale. Maintenance is not considered construction. Cleaning and dehumidification services, drying out, hauling out debris and wet carpet and wet sheetrock and wet ceiling tiles, that is not construction work. That's considered to be cleanup work. If you're going to engage in large-scale demolition, so let's say you actually have to demolish a structure or a massive portion of a structure, like you're taking it back to the studs, that is no longer going to be just removal of wet materials. That's going to be demolition, and you need to treat that like construction. It will require prevailing wage compliance and payment and performance bond compliance. But if it's just removing wet sheetrock and building materials, then that will be cleanup. There is some gray area here, so you're going to have to exercise some good judgment as to whether or not the vendor is going well beyond just removing wet materials, engaging in more complex demolition. If you are just replacing a room of carpet or a few rooms of carpet, that wouldn't be considered under normal circumstances to be construction services. But if you have a whole building that has to be recarpeted, re-drywalled, new ceiling tiles, replace smart boards and things like that on a bigger scale, you're no longer in cleanup or restoration activities. You are now engaging in reconstruction and alteration and renovation activities. So again, you're going to have to exercise judgment in that gray area, but I want you to be very careful because we did have situations after Ike where suppliers were not paid and subcontractors were not paid. And we got into some battles as to whether or not the services that the vendor was engaged in were the types of services that required a payment bond. And it's important for you all to monitor that because especially if you're going to be working with vendors that you've not worked with before or aren't through a co-op or you didn't procure, if they don't pay their subs and suppliers and it turns out it was construction services and not just cleanup and debris removal and dehumidification services, then you as the school district are going to stand in the shoes of the surety. And if that company didn't pay their equipment suppliers or subcontractors or material suppliers or even their fuel suppliers, which was the dispute I had after Allison, where they had brought in a bunch of generators and didn't pay the fuel supplier, and somebody was trying to make a claim against the governmental entity that they should have had a payment bond and they wanted the entity to pay their bill. Well, I was able to defend that by saying, wait a minute, this was fuel to operate generators to provide electricity, and that's not a public work. They were running dehumidifiers and temporary chillers and things like that. That's not a public work, and we didn't need a payment bond. But if somebody is not paid and they were doing massive ceiling tile replacement or flooring replacement or electrical repair, then you're going to want to make sure you have a payment bond to protect yourself. And so hopefully that clears up some of the confusion as to what is considered disaster mitigation and then where you cross the line and start going into reconstruction. Now I'm going to turn it over to Jonathan, who's going to talk a little bit about preserving your entitlement to FEMA reimbursement.
Good afternoon. This is a fairly broad topic that I'm going to cover in quite a bit of brevity because there's a tremendous amount of details involved in seeking reimbursement from FEMA. But as many of you may know, and will all know now at least, that the FEMA provides public assistance grants to state and local governmental entities to help cover the costs of disaster recovery, and in particular to cover those costs that are otherwise not received from insurance or other funding sources. In other words, FEMA's public assistance program is a gap filler. There are several things we've talked about today that are relevant to helping make your ability to get reimbursement more successful in the future. And those relate to contractual provisions that Mickey has talked some about, as well as particular things you can do on the ground. The first thing I want to point you all to, and it's cited in the slide as the first bullet on this page, FEMA has put together a fairly comprehensive guide. It's almost 200 pages long, and it has citation to all their regulations, rules, and examples. It's available on their webpage, and they've recently revised this document as of April of 2017. What I really want to zero in on for you all, because it ties the most into this presentation, are some of the requirements for contracting and monitoring the work that is being performed. So FEMA, and I'll particularly point you all to page 33 of the guide when you get it off the internet, talks about the kind of contracts that FEMA will reimburse under. And you'll see that some of the requirements FEMA wants from a contract are the very same ones that Mickey talked about earlier. Guaranteed price, rate sheets, the ability to monitor a contract and verify the charges that are received under a contract. And that's very important. FEMA's regulations have recognized and impose a requirement upon the governmental entity to monitor the work that's being done. And this is going to be critically important for y'all to monitor disaster restoration and remediation work that's being done so that you will be in a position to verify as you make submittals to FEMA on the workmanship. So FEMA recognizes that contractors have an incentive to make money, and their incentive frequently is to make as much money as they can, and so FEMA will discourage the use of time and materials contracts as a contract method for disaster recovery and remediation. But you can still use those kinds of contracts when no other contract is suitable, the contract has a ceiling price that the contractor exceeds at its own risk, and, quote, the applicant provides a high degree of oversight to obtain reasonable assurance that the contractor is using efficient methods and effective cost controls. FEMA opposes that requirement so that the data that they receive in a reimbursement application is not only generated by the contractor. In the past, we've handled disputes where contractors have submitted wholly fabricated documentation for materials, for labor. They haven't been able to back up their charges and have simply created documentation. Of course, if you learn that documentation is created fraudulently, you can't properly submit it to the federal government. To help cure that, the district should have a point person or persons working to monitor what is going on, to independently verify where your contractors are working, the amount of work they're doing, the amount of debris that they are hauling off. And while I recognize that's a burden, it's a burden that is imposed by the federal government if you want to down the line successfully close the gaps in your cost recovery. Now, FEMA has discretion to make payments in any event, but you don't want to be in a situation where a small degree of monitoring costs you the ability to get reimbursement later. Ultimately, keeping very, very, very clear records of the work that is performed for you, the costs that are charged, and the backup is critically important because you'll have to submit that information in your payment requests to FEMA. And also importantly, FEMA may make initial payments, but they will come back over the subsequent years and audit you. And you'll need to maintain that documentation to make sure that you're not required to subsequently return money that you've already been paid.
Yeah, the audit period, I'm sure all of you have heard about districts or other people who are still trying to get FEMA reimbursements from storms that happened years and years and years ago. So it may be that requiring vendors to retain these records just for the typical 3 years that a lot of contract templates have may not be sufficient. So you're going to want to make sure that that audit period and duty to maintain and allow inspection and copying of records is not limited to a time period that won't be of use to you in an audit down the road.
And certainly maintain your own copies of the records that you receive from your contractor and the records you generate in-house until the point where you're advised by FEMA that the audits are closed and your reimbursements are final. As you're going through this process, it's best to monitor and document as much as you can all of the cleanup and restoration work that is being performed. Not all of it will be reimbursable. FEMA has categories of eligible and ineligible reimbursement services, but trying to get a mastery of FEMA's regulations before you start work is probably not going to be possible. And so if you manage to keep records of everything and you can submit as you go, you can make the determination as to what is eligible and what is ineligible. But having the records and the documentation will assist you with that.
Thank you, Jonathan. I am not seeing a lot of questions roll in, so hopefully that doesn't mean you're so supremely overwhelmed. I know we're all overwhelmed, but I want you all to know that if you think of a question or your institution has a question as you're discussing this or reviewing this, or you need something clarified, please do not hesitate to reach out to TASBO, and we can try to clarify or provide that information. Obviously, you know, many of you may have your own in-house counsel or outside legal counsel, and you'll want to work closely with them on these resolutions and these board meeting postings. So it's just our goal to make sure you understand what your options are and how to go about carrying those out in your own jurisdiction, but we're certainly ready and able to help clarify anything that wasn't clear today, or if there's a question you think of later that you weren't able to ask. Again, I think this PowerPoint is being made available. We will send a template resolution to TASBO so that you can get a link to it, and with the caveat that, you know, if you're a charter school or you're a junior college, you may have to make sure that you capture any, or even a school district, you may need to capture any changes necessary on your end. You know, I sent it to HISD. They're a board of education, not a board of trustees, you know, and so those things that you need to tailor it on your end, please be sure to do that, but we mean it only as kind of a guidance of what you would expect to see in such a resolution. Let me go down here and see if there are any more questions. The timeline to file with FEMA. That I don't know, and I don't know if it changes from disaster to disaster, so I don't know of any bright line rule. I really would recommend that you get on FEMA and register. They've been telling people on the media to get on the website disasterassistance.gov and try to find out. I do not know what the deadline is, but I do know that I've had clients in the past who for one reason or another needed additional time, and they could put in placeholders or preliminary requests and then continue to work out their PWs and get extensions for those as necessary, but I would refer you to FEMA for that as it relates to the timeline. Go ahead, Jonathan, is there something else?
And that FEMA manual that I referenced earlier does have guidance on how to make your submissions and project deadlines in terms of project documentation, deadlines, and submissions. So I would encourage everybody to have at least one person at the district who becomes a master of that manual, and it will provide most of the information you need in terms of submission deadlines, the length of time for which funding is available from the triggering event, which of course is the disaster occurrence and declaration. And of course FEMA has the discretion, they have a great deal of discretion in administering these programs to extend deadlines.
Okay. We have a question here. What if we have a contract for remediation but another company can service us faster? Can we get services from the other company? You need to look at the contract that you already have in place to determine whether or not it's an exclusive contract. If you're obligated to go to that company first and use them, you do not want to be in a situation where you have breached the contract by allowing another company to do the work. So have your legal counsel look at that agreement to make sure that there's not an exclusivity provision, and if there's not, if it's just a lock-in just in case, then you shouldn't have a problem using somebody else. You just want to be very clear, and don't just look for an exclusivity provision. Read the whole contract, because it could be language, somewhere else in the contract. It
Even
could
in
be
the notice provision,
yes.
It says you have to provide notice to us
Yes.
prior, something along those lines.
Or just the word, sole, where the sole provide, you want to be very careful that there's not something hidden in there that you need to be aware of. Can you also provide a template addendum to contracts that you mentioned earlier? Happy to. We're going to take all these provisions that we recommend, and so again, I had the situation this morning where I had, minutes to review a contract and wanted to add provisions, and I had the idea of, well, if we could just put all of these, our contracts have to have these provisions in an addendum that the vendor and the entity sign, and it says it takes priority and supersedes anything to the contrary in the vendor's agreement. I think that would be ideal. I unfortunately wasn't able to do it this morning because I lost my laptop in the flood, and so I'm trying to do everything on my phone. I'm hoping to get another laptop tomorrow and borrowing computers from other people, but we will put that together and send it to TASBO, some recommended provisions in an addendum you can use. Jill, if your board approves the resolution to suspend, do you specify an end date, or is that left open-ended? That's a great question. And obviously, your board will have some concerns that this could be subject to abuse. How long does the emergency go on? And so I want you to remember the standard, and that is that the procurement rules can be suspended because the delay posed by the procurement process would substantially impair the conduct of classes or other essential school operations. So you're going to have to run that test with every contract, and if you get to a point where, okay, it would be convenient to have this done, but we don't have to have it done to conduct classes or other essential school operations. It's obviously not a bright line test.
It's not a next number of days.
Yeah, it's not a day or anything like that.
But it's also not, while we're doing this,
Correct.
We may as well make this addition we were planning to do.
Yeah.
No, that doesn't fall under the exception.
And you also have to ask yourself whether something is an essential school function, because if you have to get electricity and air conditioning and flooring in and bathrooms and kitchens running, well, then you need to ask yourself, well, we lost all of the softball equipment, but softball season doesn't start until next, April or March. I can't remember. My daughter used to play, but, so you're going to have to ask yourself, can we afford the delay? Because you're going to need to show your auditor when they come in, when your auditors come in and ask for your procurement documents for your contracts over $50,000, and your defense is going to be, we did this under the emergency procurement exception because of the delay would impair the conduct of classes or essential school operations. You need to be able to convince your auditor that that was a true statement. One, that it was related to the emergency and not, oh, we really needed new turf and now here's a great opportunity to get it because school is out for, a couple weeks. It's got to be related to the disaster, and it's got to be necessary so that you're not delaying the opening or resumption of school activities. Steve Vero. Hi, Steve. For professional services, you mentioned that qualifications, not price, would guide supplier selection. However, formal RFQ is not required. That is correct. For your professional services, you do not have to do a formal RFQ with the exception of, and I can't imagine you'd need any of these as it relates to disaster recovery, you have to do an advertised RFQ for a CM at risk. So if you're going to bring in a CM at risk to do actual reconstruction and remediation, and it really is the repair and the rebuilding necessary to get your classes and your school operations going again, then yes, you can do a CM at risk contract, but you don't have to procure it as such. So you wouldn't have to do either the RFQ or the RFP for the CM at risk, one step or two. I wouldn't do a two-step. If you've suspended procurement,
Right.
You've done it for a reason. I wouldn't do a two-step. I'd just bring in a CM at risk.
But knows, too, that that's only for the true professional services.
Yes.
The ones listed in 2254 and in 44031.
Yes.
Not, these, this is a consultant, like for
Yeah.
insurance, for
Yeah.
example.
So if you've suspended procurement, it's not going to matter whether it's a professional
Yeah.
service or non-professional service. You can just do it. But an RFQ, if it is required and you need it for an emergency, you won't have to do the RFQ process. The form on the website has an expiration date of 2008. The form on the website. Is that the FEMA website? Yes, the FEMA website.
So it took a little bit of looking for me to find on the FEMA website, but FEMA published their new guidance manual in April 2017, and we can see if we can get that web address to TASBO.
Is there some... Yeah, I see it. Is there some relationship between FEMA reimbursement and utilizing the Xactimate? So the Xactimate unit price book may be required by your insurance company. So if you have flood insurance or property insurance at your district or institution, they may require your bids to be submitted in Xactimate format. FEMA does not require, as far as I know, I've not seen, certainly wasn't true in the last storm unless they've changed something in April 2017, but making a FEMA reimbursement claim requires that you have contracts and backup to justify the expenses for which you're seeking reimbursement, but not a requirement that the providers of the services go into Xactimate and give you that type of unit price takeoff that the insurance companies will provide. So if you're working with an insurance company to make a claim as opposed to FEMA, you want to make sure you clarify with your adjuster whether or not they're just going to settle the loss with you and give you the money to go execute your own contracts, or if you're going to have insurance make direct pay to the vendors, the carrier may require those bids to be presented in an Xactimate format. You're just going to have to ask your adjuster, but we've not seen that requirement ever as it relates to FEMA reimbursement.
And so remember, FEMA it works in conjunction with insurance. Where insurance covers the loss, you're not seeking FEMA reimbursement for that portion, particularly with respect to debris removal of damaged materials. We've never seen any requirement that you use particular estimating. FEMA recognizes that the exigency of the circumstance requires you to act.
But while we're on this topic, I do want to make sure to point out that if you are fortunate enough to grab a cooperative vendor to do this, you're going to want to make sure that that co-op vendor is only charging you the rates that they submitted to the co-op when they were added to the co-op pool. So if it's a time and materials for non-construction services, ask the co-op for the rates that they submitted to the co-op. You should be able to see those and make sure that they're not giving you jacked up rates, because even in an emergency, they can't gouge you with higher rates or charge you any higher than the rates they had submitted to the co-op for emergency services. If it's construction work that they're doing, they're going to have to show you that they arrived at their proposal for the construction services using whatever RS means or unit price book that the co-op told them to use, and those coefficients that they apply need to be the same coefficients that they quoted to the cooperatives, with no premium or markups for emergency unless it's specifically provided for that in their bid or proposal to the co-op. Please also double check on co-op contracts whether their coefficient is already supposed to include markup for overhead and profit, and insurance and bonds, so that you're not getting a quote from a co-op vendor that has the proposal for the work and then a separate line item markup for bonds, insurance, general conditions, overhead, and profit, because many times the cooperatives tell them, no, that has to be factored into your coefficient, so there shouldn't be any markups on top of that. Please double check those.
Especially for overhead and profit.
Yes.
Most of them will allow you to do a pass-through of the bonds, the bonding price, but not overhead and markup. It specifically says you're supposed to use the RS means, for example, with O&P included. So be careful with that.
Yeah. Yeah, you're going to want to make sure, if you're planning to make a FEMA claim, that you go through that guideline, because I'm seeing comments on here, thank you, from HCDE, that there are certain specific things that they want in that documentation: wage rates, verified payroll, services lined out per job. So you need to know what per job means, per campus, per site, and make sure that you're setting up your contracts and your documentation in the way that FEMA is going to require you to submit. And don't be embarrassed if FEMA kicks it back to you and has you rework your PW, your project worksheets. That happens over and over. It happened to most of the people after Ike and Rita and Allison, but just keep working with them. You'll get there. Thank you. That was Stephen Kendrick who pointed those out. Needed for OIG audit, or they can take the money back. Yes, that is true. If FEMA gives you a reimbursement and then they find problems in the audit that you paid for things that you shouldn't have paid for, red dye diesel is one of those things we kept seeing after Ike. They will not reimburse for red dye diesel. So if your folks are using generators or equipment with red dye diesel, they won't reimburse for that fuel. Yes, they will come back and ask for that reimbursement money back. So if anyone has any other questions that you come up with later, please get them to TASBO. They'll pass them along, and we hope everybody stays safe and gets through this, and that you can get your kiddos back in and your college students back in and your teachers back in. We are here to help if you need us, and hopefully now that the rain has stopped and waters are starting to recede, that people can at least try to adjust to the new normal for a little while. Oh, Tracy is posing as Jason Meek. Hi, Tracy. I want to shout out to Tracy Ginsburg, TASBO's awesome executive director, who called me the first day after I was displaced, and she and I came up with the idea to do this, and her dedication to all of you to get this information out. Really, I hope it's helpful, and I hope everybody enjoys the rest of their day. Thank you.